and we have with us Swapnesh Sherikar, Justice Ribello, and Francis Coelho. Without further ado, I hand over to Justice to go through the entire reason for this press conference. Thank you.
Good morning to everybody.
Thank you.
English will wake up. Cognitive Java, that's the level to but basically flow of thought, English is Sir के जाना चाहिए. When we had the first meeting of people interested in protecting the environment ecology of Goa, I am going to guide the Jasa. I had done some study, maybe not a very detailed study, and progressively we have, I have been going through the other laws, and yes, on 30th I have now written one more letter to the Chief Minister of Goa. It could not be delivered, but it will be delivered on Monday. But I was just telling basically what are the points we have made in this letter, and based upon documents now in our hands. Now, first issue to our training Santale, and as we are saying, that Section 72 of the Town Country Planning Act has now been read down by the High Court. आमची मागणी पहले असली कि this whole thing should be scrapped, but to be repeated. But in view of the High Court's judgment, and if the judgment is not interfered by the Supreme Court, we are now not saying scrap the entire Section 72, but amend the law in terms of the judgment of the High Court. So Section 72 should be amended to bring it in tune with the judgment of the High Court. And yet, what does this mean? This means that you cannot make major changes in the regional plan of Goa. Now, the regional plan of Goa shows, just if you see on the slide on the screen, how the lands have been earmarked for various purposes. Now, where first is Eco 1 zones. Now, these are zones which cannot be touched at all. And if you see at the end, paddy fields, hazard lands, they are not supposed to be converted. Then we have Eco 2 zones, orchard land, cultural land, salt flats, fish farms, and so these are what are known as Eco 2 zones. Some perhaps can be changed or not, and some cannot be. And then if you find the balance zone, now why balance zone is important is for this issues. Now, I was not aware of this law called for the purpose of clearing files for industrial activity. It is called I think promotional board or something of sort. Inward promotional board under that act. Now, if you see settlement, we have about 527,000 square kilometers, and this constitutes 14.22% of Goa's land mass. So, out of 3,500 square kilometers, 526 is reserved for settlement. Then we see industrial, and this constitutes 14.22%. Industrial 41.96 square kilometers. Now this is not meters or hectares. Square kilometers is 1.12 of the land mass. In other words, there is sufficient land available which is still not developed, which is earmarked for industrial purposes. And then total so and so that this constitutes, and forest cover is 35.50. So all that makes up 100% of land use. You see on the chart, Tata Primal level, you will see how in the regional plan, the land has been earmarked for development until this regional plan is revised. And when you make a regional plan, all these aspects are seen the need from Goa for these years until it is changed. So 17 to now, the High Court has read down, rules have been struck down, the guidelines issued have been struck down, and all files have now, which were there, are pending. Earlier files, what we done is another issue which I'll see afterwards. The second is section 39A. Now this section 39A is a surprising section. 16B, which was brought earlier, was repealed, and 39A has been introduced. Now what is 39A? 39A is, you go to the office of the town planning department, you got some question, there is money in your pocket. You walk down there and tell them, yes, change it into settlement. Convert the paddy field into settlement. I am paying the money. This is the money you are asking me. This is the money. And Town and Country Planning Board in Basra, and they grant permission. And I think Goa knows now that these are all cases of with pro quo. With pro quo meaning for this act, something else is happening. I think people of Goa, I think, have now opened their eyes and they are realizing what is happening. So this section seeks to change the entire regional plan. Our arms mandate is that this must go. Third is section 32 of the Land Revenue Code. Now section 32 of the Land Revenue had given power to the collector whether to grant permission to convert agricultural lands or not. And collector has to do it in terms of the law. Now they have amended the war section 32 amended. I will come to the next law to help conversion of paddy fields under restriction of transfer of right, Agricultural Land Act 2023. I have thereafter shown the slide. So to help this law, the collector can now grant permission to any kind of land, whether it is falling in Eco 2 zone or any other zone. So the result is from 2023, I am very specific. 2023 onwards, laws have been amended to change the face of Goa, to help builders, mostly from outside Goa, to come in, destroy our paddy fields, destroy our hill slopes, and put up constructions which none of us, including me or you, can ever be able to afford at the cost of our infrastructure, at the cost of our water supply, at the cost of our drainage system, sewerage, which are non. So this is what we ask, and repealing of section 2E of this act and section 17A. Now section 17A was a good measure brought by the government then there in 1991. It was a welcome measure. And power was given to the town planner to exercise discretion to grant permission or not for hill cutting. But those of you who are familiar with law will know that to give effect to the provisions of an act, there must be rules. No rules were ever made till date. Town and Country Planning Board made some guidelines which, according to me, to those who are will know law, are illegal. And under those illegal provisions, permissions have been granted. And there is, for the hills counter, that what is called topo plans prepared by the Surveyor General of India. Those have been followed till 23. till 23. 20 till नवी guidelines काढली. Again illegal. And suddenly private architects सांगपा लागले, what is the counter 25 grade? What is that counter? Now I'm asking everybody a question. If the office of the Surveyor General of India, which does survey throughout India, has done surveys also in India, in Goa, some private architect is going to change the proper survey. Want the Munda, this was not done properly. I can understand. Go back to the Surveyor General of India, sir. Yes, I can proper Kerala redo it. I can understand that. Legally permissible. But then, for private architect, आपका question है, this is not correct. And unfortunately, some issues which ought to have been highlighted before the courts were not highlighted. The court said we are not experts, and the town and country planning board says that what is done by the private architect is correct. We are going back. The court never asked the question, what about the counter plan of the Surveyor General of India, which I frankly should have been the first question to be asked. The court did not address itself on the question, where are the rules for you to exercise discretion? But hopefully we are trying to file another petition to regulate the situation. So this act, in the post, after Shirlekar had filed a petition regarding non-payment for change of zone of under 17. Now that file went to the government sent it to vigilance. Now vigilance had applied report, but their report we'll forward the entire file on Sandesh. Please thereafter send the entire file to everybody. Paragraph 19, out of 188 files in the Dandelion, randomly the vigilance department picked up 11 files. And in all 11 files, the vigilance department has shown how illegalities have been committed in those 11 files, which could never have been committed, in respect of which permission could never have been granted. Now, I have in my letter to the Chief Minister, I have pointed this out. I have further demanded, Shirlekar has already filed a complaint. This report has been filed with the police. We are asking the Chief Minister of Goa that immediately FIR must be filed in respect of these 11 cases. All officers, all members of the Town and Country Planning Board who were involved in clearing this file should be looked into, and the rest of the files also the Vigilance Department must look into. Because this shows the kind of corruption that has been going on in the Town and Country Planning Department. After extension, some town country planning has been suspended at the back end of his career. That's okay, because he was one of those persons involved. But why only he? Why not all those persons who were sitting in those committees granting these permissions without looking into whether proper material has come before them to decide the issue? I can understand somebody saying, I did not know, I was there. That will show afterwards, your bona fide will show afterwards. But first, that FIR be filed and criminal cases be initiated against all these persons. This is the letter there. And more importantly, here are the slides they get is to show from the very beginning how we try to protect our agricultural lands. Right from 64, when the Agricultural Tenancy Act came into force, we tried to protect our agricultural lands from conversion. So please show now the next. Some few facts.
Very good. He get it. HDMI no signal.
Now we are just showing some figures of conversion of land. Okay, under section 17(2), so far granted, what we know out of few files, 2,40,507 square meters. Most of them are on gold now. 39A, the area is 17,26,202 square meters. So these are some applications which were made and granted under by the Town and Country Planning Board. A lot of the files now pursuant to judgment of the High Court on 17(2) are under hold and until the High Court further decides the issue. Come the next slide, please. Now this will show you the applications which have been made for conversion of land outside the settlement zone. So for orchard land, 95 cases you will find down there. 12,81,000. Natural cover, 6,91,000. Cultivated paddy, 3,33,000. Khazan water body, 88,17,000. Settlement, total 28,43,577. And now they had second figure about 8,41,42 have no development zone, so classified in those zone. Now here figures these are figures taken from government documents and the subject matter of the petition. So in the matter of 23 onwards, this is the nature of the land which is sought to be converted by using section 17(2), by using section 39A. So just see the anomaly, this is what has happened to our land, to our non-convertible lands in Goa. So come next slide, please. Now I'll show you what was the position of the laws before these 23 amendments. I will also point out that there is one amendment to the Code of Govindas, which is a progressive step, will come to that after. That is the only exception. Now, the first one is the Tenancy Act of 64. Now, in Tenancy Act of 64, if you see bullet point number 3, what was agricultural land? Bullet point number 2 is agriculture, that is paddy fields, etc. Garden and garden produce, which is orchards, that is cashew, mango, coconuts, are all included in this definition. Apart from that is 31A, tenant could not be converted without permission, and even non-tenanted, but bullet point 4, government could step in and stop conversions. Then all is other. So from the threshold, legislatures in Goa had the intention of protecting our agricultural lands under the provisions of the Goa Tenancy Act. Now, why is this important? This is important because there are over 161 Govindas in Goa. Most of the land belong to Govindas, which were given, I'll come to that slide later on, either on short-term leases, long-term leases, or emphasis. So these were, all these talukas, from Kankana onwards to, I don't know about what it was in Petne, the new Congress does, but rest of 161 Govindas, from Gaonkaria they became Govindas. And Govindas gave the land in turn to the people. So these were all lands belonging to the Govindas given on tenancy, and under the Tenancy Act, either the tenant or the subtenant could not convert. Come to the next slide, please. Then came the Goa Land Use Regulation Act 1991, a very, very important act. 91 who was the Chief Minister in 91? I think it was Mr. Pratap Singh Rana. And in 21 it has been undone by another Rana will come and show you.
Louis Pepper.
No.
Louis Pepper was on, I think Louis Pepper.
Go ahead.
No, Mr. Ravi.
Ravi, no?
Anyhow, this is 91 and but let us pay our tributes and respect to these people who were there in 91, who brought this Goa Land Use Regulation Act 1991. Now, what is important about this act, and it is in force till today. This law has not been amended. Section 2, just see Section 2. Notwithstanding anything in the Goa, Daman and Diu Town and Country Planning Act, or any plan or scheme made thereunder, or in the Goa Land Revenue Code, no land which is vested in a tenant under the provisions of Goa, Daman and Diu Tenancy Act shall be used or allowed to be used for any purpose other than agriculture. So a total ban by this law against conversion, which was there in 1991 and continues to be there till today. And how they are going beyond this law, I will come later on. So just remember, this law continues to be enforced till date. Under this law, if the land was given to a tenant who became a deed owner, that land cannot be converted for, irrespective of why I'm coming to you through one, they say negative declaration. And the negative declaration means, the tenant na, so I can convert. But if it is Gominda's land, then you are either the direct tenant of paddy fields which were given on short term or on long term, or an emphasis. Emphasis is slightly different. I'll come to that afterwards. But short term leases, long term leases are all covered and they could never be converted. Now come to the next law. The bill was put by Ravi Naik, you are right now. When he was the Chief Minister. I think the short test.
Yeah, we'll be sharing my presentation with you.
Now take to the amendment to the Code of Gomindas 2025. This was done because of the Zuari land, not out of any other thing. Demand will be. But again, the only progressive steps in 23 that this government has made. We welcome this section. I'll tell you why. I will just read for you. Again, notwithstanding anything contained in this code, the Goa Town and Country Planning Act, the Goa Regulation of Land Development and Building Act, the Goa Land Development and Building Construction, so, or any other laws relevant for the enforced, any land belonging to the Gominda, if granted for certain purpose, either by way of sale or lease or emphasis or legal license, shall not be used for any other purpose except for the purpose of which the land was so granted. So this is a blanket law. Why is this important? This is important because when the Gominda would auction paddy fields, would auction long-term paddy fields, and in respect of emphasis, which is called a permanent lease, you had to apply for what purpose you are asking for cultivation. And these were all non-cultivated lands. These were not paddy fields or lands which were cultivated, but which could only be given for horticulture, which would include cashew plantations, mango plantations, coconut plantations. But you had to set out in the application, and then the emphasis would be granted for that particular purpose, which would be included in the Gominda had two books, Tumbo 1 and Tumbo 2. First entry would be the Tumbo 1, that this land is given for this purpose. So you can immediately identify that this land was given by the Gominda for this purpose. So under this law now, 25, if it was given for agriculture, you can't use it for non-agriculture. If it was, for example, this came in instance of Zuari, because that was the issue we debated in the house. So if Zuari had given the land for industry, under this law now, perhaps I don't know the facts, you can't convert it to residential. This is the law. So this is a very important law insofar as conversion of lands in Goa. Now come to the next slide, please. That is the object. Yes. Now I am just highlighting this. Mount Abu started giving negative declarations. One Matalo, there would be a developer behind, landlord Astalo and tenant Astalo. Now, how do I blame either the landlord or us? See, all of us are ultimately what are the Krishna. And if I get some money from something which I was not getting from the land, immediate thing is, let me sell. But you sell it. If you don't have your land for your future, then you should tell that. But why? We are against these developers who corrupt the system. Let not that person who has taken the land be allowed to change that land. If it was a paddy field or orchard land, he should not be allowed to take advantage of a distress sale by own tenants or owners. These are basically distress sales. Distress sales because they are not getting much produce from this land in line, and therefore out of that distress people are selling. So I can't blame them. But I am saying is you cannot allow that developer to change that land. That is that. Purchase it and keep it as it was. No change. Come next slide. Now this is what I am pointing out. The betrayal of Goa by the legislature. I have used the words deliberately, chosen, Yutrame, specifically put in to show how the Goa legislature has betrayed the people of Goa. And this betrayal are by one. Early attempts are now to bring section 16B in 2018. The process started in 2018. Then this I'll come. 18th April 2023 came under law. The Goa Restriction of Transfer of Agricultural Land, now by this if you read it, beautifully worded law, now somebody immediately flushes. Why are you fighting this? This is a law to restricting transfer. But there is a howler. In everything there's always somebody knocking out something. Now see the definition of C. Agricultural land means a land which is presently being used for cultivation of paddy, but does not include the land which is earmarked for the use of purpose partly or fully other than any plan prepared under transparent and institutional heat. Yes, now the procedure. Section 32. No, this is land. No, that is land.
It is not there.
C. Isn't.
2C. Means the land is presently being used for cultivation of paddy but does not use well other than any plan prepared under the Goa Town Development Department. So with the using section 17.2 and 39A, if you bring this land into settlement zone, under this section, the paddy field which otherwise could not be converted, under section 91 of the under 91 Act, by this is attempted to be converted. Now why I am pointing this out is that section says notwithstanding any other law or notwithstanding any plan prepared by the Town and Country Planning Department. So even if using 17.2 and 39A, if you change it, that law says you can't convert it. But that law is given a bypass. And using this provision, they are granting permission which they can't grant. even as of now. So this is a wholesale loot. If I view as a judge, it's a very strong expression for me as a judge to use. Politician may use it, but for me to use is a very strong expression. This has been used, this section has been used contrary to the provisions of the 91 Act. Under this section itself says, that section, can you please come back to section 90, just to point out, 91 Act. Before this, yes. Yes. Now please again look at section 2. Notwithstanding anything in the Goa Andaman Town and Country Planning Act. So if under the Town and Country Planning Act we declare the slice scheme card, this says nothing to do, you can't change it. If it was agricultural land in the beginning, you may put it in a settlement zone, you may put it in an industrial zone, but this section says you cannot convert it. And in spite of this section, Town and Country Planning Board and the Promotion Board are granting permission, which they cannot do. Now please come back, go back. Good. Forward. Yes, next. Section 17 to Badal, I have pointed out already that High Court has now read down the section. So their hands are now tied. In so far section 17 is concerned, unless the Supreme Court does something. But here let me tell you something now. If you have read the national newspapers, I think local newspapers have not reflected it. But two judges of the Supreme Court of India, two judges, I will not name them, so that will not be proper, are asking counsel in the court, what are you doing to Goa? Why are you making Goa a Bombay? We can't allow this. These are the words reflected in open by two judges of the Supreme Court of India while hearing a matter. Now, judges of the Supreme Court of India are concerned with Goa. Are we not concerned? Should not we fight for this Goa, which even the Supreme Court today is saying we will not allow it to be converted into another Bombay. And this has been carried by the national newspapers. These are not my words. I am reading from what I read in the national newspaper, like the Times of the Hindustan Indian Express, about 6 or 7 days back. So, Ajahni, that in Delhi, judges of the Supreme Court have started awakening as to what is happening in Goa. And our legislators are allowing, by amending the law, to convert our land, to destroy our ecology and environment. Then please come down. No. Then 39 I have brought out the matters pending in the court. And also, I think the Chief Minister who spoke, that we have spent about 9 crores of people's taxpayers' money for defending the challenges to this act. And who is funding these people? Let me tell the Chief Minister, there are lawyers in Goa, there are actors in Goa who are doing it pro bono. Pro bono means free of charge. Some are doing it for very few fees. So people of those who are fighting for these cases in the high courts, for the petitioners, are not being funded by anybody. They will not, some of them may charge lesser fees than what they would have normally charged. Some of them are doing it free of charge, including sometimes coming from Bombay by paying even their air transport. So there are people in Goa, there are lawyers who love this land, who love this place, either because they are from Goa or they are outside, who do not want to see what is happening to Goa. They want to see the preservation of this Goa. So this is and in section 17A and Shagalam, section 17A is very important. Do we require our hills to be cut? I'm asking a question. On our plains, is there no land for constructing buildings, houses, for residents of Goa? When I mean residents of Goa, let me also make it clear. Because time and time people ask me, my parents were not born in Goa before 61. Am I a resident of Goa? Am I entitled to participate in this movement? Let me make it very clear. And as I said, when I was in the Goa Assembly, and I told somebody podcast yesterday, when our school started, I'm teacher, where did the teachers come from? We did not have teachers. Our teachers came from Kerala, Karnataka, Maharashtra, who started teaching in our schools. When we started PWD, electricity department, where did our engineers come from? We have no engineers. People came from all over India to man this. So are they not a part of this Goa? And somebody comes and stays in Goa and willing to fight for this Goa. Are they not a part of us? We are not against anybody. We are against those who come to corrupt our system and by that corruption to change our land. We are against these people. All others as Indians are welcome to this land. This land is much home to them as home to us. If they are interested in protecting the ecology, environment and as any law-abiding citizen, they are a part and parcel of this Goa. So I'm very clear, this movement is very clear, we are not against anybody. If smaller jobs are taken, because we don't work, somebody has to do the job. Our carpenters are coming. कोई masons used to come from Perne. हम जब हम घर बांधता लेते पेटने चार लोग पेटने चार क्यों किया जाता है I think practically mechanization now mechanization is the so we don't require to clean them up. So practically the masons have gone. Our carpenters have practically disappeared. So this is just a so therefore this was the idea we presented to show. Today's idea was to show that there are laws, and under these laws you cannot convert tenanted agricultural lands, and most of these lands were given by Govindas. What purpose they were given is reflected in Tumbo 1 or Tumbo 2, and therefore there must be an immediate halt to conversions, an immediate inquiry as to how, in spite of these laws, permissions be given, and as a first step, as I said, criminal cases must be launched, FIRs must be launched, investigation must start. And by the way, today morning I told another podcast, or was it yesterday? But I don't know much about this. But I was surprised that the Pollution Control Board give 20 years certificate to an illegal construction. Sarpanch is suspended, fine, secretary suspended, fine. But what about the members of the Pollution Control Board and the other people? Why are they still there? Why is an FIR not launched? As to how a 20-year permission could be granted for an illegal structure. Somebody may be tomorrow acquitted, fine. I don't say that we condemn them. But an inquiry must start as to how permission, a clearance was given to operate for 20 years, and which has come to no partly other land. So, I'm so slogan enough is that that is coming out. And earlier people were not willing to talk. Okay? The other day I read my former SP Bosco George. People are not talking. Chief Minister asked them to not act on the cases. No. what stages have we reached? And these people must answer the lower people. I will not take names. But they must answer, and people must start asking questions. Komundar lands from the TV, from Sir Lagila. The guidance of Purelaga, the law which I have seen, unless it is amended, allows maximum 2 lakhs. If 2 lakhs is the maximum, how do we give 6 lakhs? Komundar has no power. But that section says it can give up to 2 lakhs. So again, this is the prima facie. I have not gone. The law is amended, but when somebody asked me, I just sent them this note. I have studied the code of Komundar's Vasa. That shows maximum 2 lakh square meters can be given. So this is the position in Goa today. And women to tell us, what are you not doing? Why are you not going on the roads? No, we are not going on the roads. We are building an organization of activists throughout the Goa. This is not going to be just people moving out. We want every active NGO. We want people in every nook and corner of Goa to stand up, to organize in their own places. Because we can't go to every village and town. It is just to be a people's movement. Facts of Dakila, kinds of Dakila. You have been, the press has been a very good partner. Let me thank the press. You have been a partner in this process, in what we have started. We want to active support. Please project these figures. Please project this law. We will give the entire file which with this. So Sandesh will send to everybody who is present over here. We have got it on the soft copies are available. So facts, figures are there. Kindly demonstrate to the people of Goa by facts and figures. And yet guidance that with the existing law you cannot make changes. So halt immediately all conversions of land, except I am willing to accept one thing, not conversion. If a local resident has some hardship, allow him, suppose dogs and bawasa, house is too small, they want to construct another and perhaps the zoning may be right or wrong. Such marginal errors, give them. But we have no objection to correct such marginal errors. Where in the hope some other brother also wants to put up a construction to have a house of his own for his family. We have no objection to that. But this large scale conversion, putting up buildings, I'm going to press us in our villages and towns, I'm kidding. These are one of the matter. But one of the choices of matter is anybody getting for 8 hours, 10 hours, Mukhyamantri 4 hours. High Court order is on 2 दिन हम क्या देखा कि 2 वर्ष छोड़ सोमना के अंदर 2-3 दिन से ही ना एक बार था sometimes 2 प्रश्न आगे मल्टी FR चेंज जाओ FR is changing रस्ते देता है ना but FR is changing multi-story buildings are coming up. So this must stop. So thank you. Any questions if you want, I am pleased to answer.
Sir, the main question which all people are expecting from this movement, that after that 6th meeting, you have submitted 10-point charter of demands to the Chief Minister, but you have not received any response from the government act-wise, as you have demanded several 10 points in that charter of demands. So what will be the course of action of this movement if those charter of demands have not fulfilled by the government?
Thank you, Kishore. As I said, this movement will take 2 courses. It will use the court to the extent possible by filing petitions, for example, like against 39A, 17A, which is under process, and it's also going to be a movement of people. Now, movement of people if the government, so far the government has not responded, I have not heard any response, nor have I heard that in the assembly, whether any questions were raised or whether the Chief Minister has said anything about the points raised by us. But we will, grassroots organizations at Nada level, and we don't want to end this in chaos. We want to be an organized, sustained movement. For the present, for this chapter, for these points, and I think by another month or so, we should be in a position to have, because activists, meeting we have been trying to, we have got some of their phone numbers, we are now trying to bring them together, and hopefully once the organization starts, we will focus on one or two issues, immediate issues, and move forward. So that is the way forward that we are looking at.
So then immediate demand is to be real cutting the stop but they अजूनही काय केले ना ते
अजून काय येत ना and अजून काय झालं but we would see I spoke to the Chief Minister specifically on this point. This is something that we can do immediately. There are no rules. So stop it. But I have not heard anything or whether any action has been taken for directing the Town and Country Planning Department not to grant any permission.
So, but even then, if it is not granted the permission, still the hill cutting is going on, and even the flying squad, if they come to the site, they are not submitting the report or they are not taking any action.
What happens is, suppose permission has been granted, I am talking in law. If permission has been granted up to a grade of 25, they can legally say that we are entitled. But I have pointed out that this has been given contrary to law, with there being no rules, or without following the topo map of Survey General of India. So this is something which is within the Chief Minister and his cabinet, if they are willing to do, to stop immediately. But so far they have not done. But we will within the next 15 days, we will move the court of this part of it. So this will be one of the legal parts, and that will be clear also. Lawyers argue that they will be doing pro bono. Lawyers from Bombay have volunteered, top senior counsel. They will argue the matter and they will argue it free of charge.
Good morning, Justice Gerard. My question to you is Section 17(2) has been read down by the High Court, but these same lands are now being brought under Section 39A and the conversions are being granted. So, do you not think that both these sections need to be done away with completely?
That is the demand. That 17(2), original demand was 17(2) should be scrapped and 39A should be scrapped completely. But 17(2) has been read down by the High Court. And reading down is in conformity with most laws in other states. Therefore, exceptional. In terms of some error or mistake. Error or mistake will be earlier it was marked as settlement. And by mistake there has been some minor error. But you got it should have been immediately. And suddenly can you discover mistake? Now, all those who have applied under 17(2), were they sleeping to apply after 23? See, all these applications have come because when 17(2) came in 23, 39A came in 23, and these sections have allowed them to get out of the law, leave lumber and sleep with the average. And this is not some 500 or 1,000 square meters. These are lakhs of square meters as we are showing the facts and figures.
Secondly, regarding the ODPs, many of these hill cutting and paddy fields are being allowed for conversion because they are marked as commercial or settlement zone within the ODP. So is there a demand to map these eco-sensitive zones or the ODPs as well?
Everything is marked. The regional plan has marked everything. If you go to the regional plan, all those figures that we are giving you, those eco-sensitive areas, everything marking is done, so everybody knows.
That is on the regional plan, but on the ODP.
ODP will reflect the regional plan, by and large. ODP is a for smaller areas. Regional plan is for the entire state of Goa. So within the regional plan for the settlement zone, for example, we may have some, what is the FSI or FAR as we call it. Some places it may be 0.8, some places it may be 1, but so those are ODP and regulations, they will make those areas. The regional plan is the plan for the entire Goa which is marked. And from that regional plan, the ODPs will come with some modifications.
Sir, one more thing is under 39 is the correction of regional plan of the government.
39 is correction of regional plan. 39 years they can come of hours.
But they have corrected many things like that correction of regional plan. They have undertaken.
That's what they are doing. The correction of regional plan, as I told you, the officer was you go to the office, carry a bag. I have this money. I am paying you this fees. Change the plan. And they will be obliged. Only without करना. This area can't be converted to paddy fields. Why not? Lord Dhamma scientifically, what with Mopo has passed, we don't know. But see, all these things can't happen. Antule was the Chief Minister of Maharashtra. He started allotting cement. Some areas that was given for a consideration. And he was unseated. He was removed because of the so-called allegations. On the ground of quid pro quo. Because this would happen. You see, land which could not be converted, you are walking and it's suddenly overnight converted. Now, no sensible man give the goal with this much of sense. At least we have some common sense that this has happened because some favor has been done to somebody else. Now, what favor is, what kind of favor is, whether it is in kind or whether other favor, we don't know. But there is definitely a quid pro quo.
Have you seen the Jan Vishwas bill and what do you think of that? The Jan Vishwas bill, the laws amendment bill which was passed recently?
I perhaps have not looked. I think is that all? I think we can close for the day. Thank you very much.
This presentation as well as soft copies of this CM's letter on, I will send. But considering mother number, please note down my number. And I will put it in my group broadcast also. So please send your name as well as newspaper or media which will represent. My number is 94220. Sandesh Progress 94.